I'm going to try to set an example here. We have 20 minutes, and I'm going to try to yield back some part of it. I see that Senator Cornyn is here, and I'm glad he is, because I'm going to address an issue which he raised yesterday and again this morning. And I wanted to do it while he was physically present so that when he gets his turn, he can address it. I'm sure he will. Yesterday, Senator Graham said that you had gone too far in calling the government, quote, a war criminal and pursuing charges against a terrorist. Later, Senator Cornyn asked Judge Jackson, I quote, you referred to the Secretary of Defense and President of the United States as war criminals. Why would you do something like that? As I noted yesterday and repeat this morning, these charges don't hold up. CNN fact check said, quote, both Graham and Cornyn left out important context. Specifically, neither mentioned that Jackson's allegation of war crimes was about torture. Also, Jackson didn't explicitly use the phrase war criminal. The New York Times noted that the allegation, quote, is a distortion and lacks context. The New York Times went on to say, Judge Jackson did not specifically call the former president and defense secretary war criminals. She was one of several lawyers in 2005 signing 4 essentially boilerplate habeas corpus petitions on behalf of detainees at Guantanamo that claimed the U.S. government had tortured the men and that such acts constitute war crimes, that's in quotes. The petitions each named Mr. Bush and Mr. Rumsfeld, along with 2 senior military officers who oversaw the Guantanamo detention operation in their official capacities as respondents. Washington Post noted, and I quote, one key thing to note, as law professor Stephen Vladeck does, is that Bush and Rumsfeld are named in petitions because they have to be, to clear procedural hurdles. Indeed, those petitions later named Barack Obama after the administration changed. Another is that they are named in their official capacities, not because of actions they personally took as individuals. They continued, but the larger point is that Jackson was acting as a detainee's lawyer in her role as public defender, and one of the underpinnings of the American justice system that is even the most reviled alleged criminals have the right to a vigorous defense. Would you like to comment on that statement that I just made?
Well, Senator, I would just say that public defenders don't choose their clients, and yet they have to provide vigorous advocacy. That's the duty of a lawyer. And as a judge now, I see the importance of having lawyers who make arguments, who make allegations. In the context of a habeas petition, especially early in the process of the response to the horrible attacks of 9/11, lawyers were helping the courts to assess the permissible extent of executive authority by making arguments. And we were assigned as public defenders. We had very little information because of the confidentiality or classified nature of a lot of the record. And as an appellate lawyer, it was my obligation to file habeas petitions on behalf of my clients.
Thank you, Judge. I'm going to try to set an example by yielding back about 7 minutes of my time. I invite my colleagues to follow that example if they wish. Senator Grassley, you're next.